A single vote inside the highest court in the United States has just detonated one of the most dangerous constitutional questions in modern American politics. For the first time in history, the legal shield surrounding a former president may have just cracked. At 10:02 in the morning Eastern Time inside Washington, a formal statement was released from the office of the Supreme Court of the United States. The language was procedural, calm, almost clinical, but the institutional consequences were anything but calm. The court confirmed a 5-4 ruling allowing federal prosecutors to continue pursuing criminal prosecution against Donald Trump in connection with allegations of election interference. Let that settle for a moment. 5 justices forming the majority, 4 in dissent, 1 vote separating 2 completely different interpretations of presidential power. And in the majority opinion, the court delivered a line that will now be studied in every constitutional law classroom in the country. No individual, including the president, possesses absolute immunity from criminal liability for actions taken outside the scope of constitutional authority. That sentence did more than resolve a legal argument. It triggered an immediate procedural shift across the federal judiciary. Because the moment the ruling was issued, the legal barrier that had paused federal proceedings disappeared. Lower federal courts, courts that had been waiting for guidance from the Supreme Court, now have permission to resume the criminal process related to the election interference allegations. Indictments, motions, hearings. The machinery of federal prosecution previously suspended, while the court considered the immunity question, can now move again. Let me say that again so it lands properly. The Supreme Court of the United States has opened the legal pathway for federal criminal prosecution of a former president over alleged election interference. And this is where the institutional gravity becomes impossible to ignore. Because there is no clear precedent in American history where a former president confronted a federal criminal process that was explicitly authorized by a Supreme Court ruling of this nature. Presidential scandals have existed. Investigations have existed. Impeachments have existed. But a narrow 5-4 Supreme Court decision confirming that criminal prosecution may proceed against a former president for conduct tied to a federal election. That is a constitutional moment with very few historical parallels. This is not normal. The vote itself tells part of the story. 5-4 is the narrowest majority possible in a 9-member court. It signals deep division among the justices, 2 competing constitutional visions sitting across the same bench. One side arguing that presidential immunity cannot stretch into alleged acts designed to influence the outcome of a federal election. The other side warning that allowing criminal prosecution of former presidents could fundamentally reshape the balance between political accountability and criminal law. Here is where you need to understand the deeper context. For decades, disputes involving presidential conduct have often remained within the political arena: elections, congressional oversight, or impeachment proceedings. Criminal prosecution of a president or former president has always sat in a gray zone of constitutional debate. This ruling moves that gray zone into a defined legal boundary. And the boundary is clear: presidential immunity does not automatically extend to actions alleged to interfere with the democratic process itself. Think about what that means structurally. The controversy at the center of this case was simple in wording, but massive in implication. If a president takes actions that prosecutors argue were meant to influence a federal election outcome, do those actions fall within the shield of presidential immunity? The majority of the court answered no, which means the argument that every act taken while serving as president becomes legally untouchable after leaving office has now been directly challenged at the highest judicial level. This is where the narrative stops being about one individual and becomes about the architecture of power. Because the question now confronting Washington is not just whether Donald Trump will face prosecution. The real question is, what happens to the boundaries of presidential authority after this ruling? And the reactions started almost immediately. According to early legal statements, Trump's attorneys signaled they will continue pursuing procedural challenges in the lower federal courts. That means the legal battle is far from finished. At the same time, leaders in Congress from both parties began calling for analysis of the constitutional implications, not necessarily the political implications, the constitutional ones. That distinction matters. Because once the Supreme Court speaks, every branch of government begins recalculating its institutional footing. Meanwhile, inside the Department of Justice, preparations are underway to reactivate the federal prosecution process that had been paused while the Supreme Court reviewed the immunity question. The system is moving again, quietly, procedurally, but unmistakably. And here is the detail most people outside Washington may be missing right now. The 5-4 ruling did not end the conflict. It moved the conflict into a far more dangerous arena, the operational phase of the federal justice system. Because once prosecution resumes, the constitutional debate leaves the realm of theory and enters the courtroom. And that is where the real power struggle begins. The opening shock has already landed. A 5-4 decision from the highest court in the United States has reopened the legal pathway toward federal criminal prosecution connected to alleged election interference. Now, the focus shifts from the announcement to something even more consequential. The structure behind that decision, the mechanics of power that produced it, and the system that must now carry it forward. Because this moment is not only about a ruling, it is about how a constitutional machine moves once the Supreme Court speaks. Let's begin with the numbers. The Supreme Court of the United States consists of 9 justices. That structure has remained constant for more than a century. 9 seats, 9 constitutional interpreters, and in cases involving presidential power, the margin between 2 constitutional futures can sometimes be a single vote. That is exactly what happened here. The ruling allowing federal prosecutors to proceed against Donald Trump passed with 5 votes in favor and 4 in opposition. The threshold for a majority on the court is 5. No more, no less. Which means the decision clearing the path for prosecution did not emerge from overwhelming agreement. It emerged from the narrowest possible majority, 1 vote. That single vote creates one of the tightest constitutional rulings in modern disputes involving presidential authority. And in a system built on precedent, narrow rulings carry a particular kind of weight. They show a court divided not just politically but philosophically. Pause there for a moment. Because when the Supreme Court splits 5-4 on the limits of presidential immunity, the country is not simply receiving a legal instruction. It is witnessing a constitutional argument unfolding inside the court itself. And this is where the internal structure of the decision becomes critical. The justices effectively formed 3 identifiable camps. First, the majority, the 5 justices who concluded that presidential immunity does not extend to conduct alleged to interfere with the federal election process. In their reasoning, the office of the presidency carries immense authority, but it does not create a permanent legal shield once that authority is alleged to have been used outside constitutional boundaries. Then there is the minority. The 4 dissenting justices warned that the ruling may open a pathway where future administrations could pursue criminal prosecution against former presidents, potentially reshaping how political disputes unfold after a presidency ends. Their argument centers on institutional stability, the concern that criminal law could become entangled with political conflict, 2 constitutional fears confronting each other across the same bench. One side arguing that immunity must stop where the democratic process begins. The other warning that criminal prosecution of former presidents could destabilize the presidency itself. But between those positions sits the most important layer of the court. The justices, often described in Washington as the institutional swing figures. These are the jurists who do not always align predictably with either bloc in the court's ideological spectrum. They are the ones who determine the 5th vote in cases that redefine constitutional limits. And according to the structure of this decision, it was precisely that swing group that produced the decisive majority. Let that sink in. The constitutional boundary around presidential immunity did not collapse under a sweeping ideological shift. It shifted because a narrow institutional coalition formed around a single principle alleged interference in a federal election falls outside the protected scope of presidential authority. That is the hinge point of the ruling. Now the focus moves from interpretation to procedure. Because the Supreme Court did not determine guilt, it did not deliver a conviction, it did something more procedural but equally powerful. It confirmed that the federal judicial system retains the authority to hear the case. That distinction matters enormously. The legal argument presented to the court centered on whether a former president could claim immunity from criminal prosecution for actions taken while in office. The court's majority did not resolve the underlying allegations. Instead, it ruled that the justice system has the right to examine those allegations through the standard federal criminal process. In other words, the court reopened the door to the courtroom, and that courtroom will not be inside the Supreme Court. The next phase takes place inside the federal trial courts, operating under the authority of the United States Department of Justice. Those courts will handle the motions, evidentiary arguments, procedural challenges, and hearings that define federal criminal litigation. The same system used for every federal criminal defendant now becomes the arena where this unprecedented case may unfold. Here is where the machinery of American law begins to move step by step. The Supreme Court provides the constitutional interpretation. Lower federal courts implement the litigation process. Federal prosecutors carry forward the case itself, a chain of institutional command. Supreme Court to federal district court to federal prosecutors. Prosecutors to the evidentiary process of the courtroom, each layer bound by the decision that has just been issued. But systems rarely move without friction. And this is where the enforcement question quietly enters the frame. If procedural conflicts emerge, the responsibility for implementing the court's ruling falls on the federal judicial system and the prosecutors operating under the Department of Justice. Federal law enforcement agencies stand behind that process, tasked with ensuring court orders are executed according to federal law. This is the stage where constitutional theory becomes operational reality. Court orders, legal filings, judicial scheduling, all of it governed by the ruling that removed the immunity barrier. But before anyone assumes a straight line from ruling to trial, several variables remain in motion. First, the legal strategy from Trump's defense team. Additional motions, appeals within the federal court structure, and procedural arguments could still shape the timeline dramatically. Second, the pace of the federal judiciary itself. Scheduling hearings, evaluating filings, and managing complex constitutional questions can take months or longer depending on the court's calendar. Third, the institutional reaction from Congress. Lawmakers from both parties are already examining the constitutional implications of the ruling, particularly the precedent it establishes for the limits of executive authority. Fourth, public opinion and the broader political environment. In a democracy, legal institutions do not operate in a vacuum. Political pressure, media coverage, and electoral dynamics often influence the surrounding landscape. And finally, the national political calendar itself. Election cycles, campaign schedules, and shifts in congressional leadership could intersect with the legal process in unpredictable ways. All of these factors will shape how the ruling unfolds in practice. But step back and look at the system from a wider angle. A 5-4 Supreme Court ruling has just repositioned the boundary between presidential power and criminal accountability. The judiciary has spoken, the prosecution machinery is restarting, and the constitutional debate has moved from theory into procedure, which raises the question now hanging over Washington, not whether the system can interpret the Constitution, but whether the system can manage what happens next once that interpretation begins to operate in real time. The moment the decision landed, attention shifted away from the chamber of the Supreme Court and toward the wider architecture of American institutions. A ruling decided by 5 votes to 4 does not end a constitutional conflict. It often begins one. In this case, the narrow majority has opened a pathway that now stretches across multiple layers of the federal legal system, and the direction of that pathway is no longer controlled by a single courtroom. 3 potential outcomes are now visible on the horizon. The first is the maximum scenario. In this pathway, the federal trial process accelerates. Judges at the lower federal level move quickly to reestablish the procedural calendar. Prosecutors file updated motions, and the case begins advancing through the ordinary stages of federal criminal litigation. If that happens, the United States would move into uncharted constitutional territory, a former president standing inside a federal criminal process tied to alleged actions involving an election. Such an outcome would not simply resolve a single case. It would establish a precedent that future prosecutors, courts, and constitutional scholars would analyze for decades. The legal message would be unmistakable. Presidential immunity has limits once a president leaves office, particularly when actions intersect with the machinery of democratic elections. And that possibility alone explains why the next few days matter so much. The second path is the intermediate scenario. Instead of moving rapidly, the case could stretch across multiple procedural stages. Defense attorneys may challenge the interpretation of the ruling. Motions could request clarification about which actions fall inside presidential authority and which do not. Appellate courts may again become involved, not to overturn the Supreme Court, but to interpret how the ruling should be applied at the trial level. If that occurs, the legal process may evolve into a prolonged constitutional debate rather than a single decisive trial. Court schedules could expand. Hearings could multiply. Procedural arguments could push the timeline deeper into the national political calendar. In that scenario, the country would witness not a quick judicial resolution, but a sustained institutional dialogue between courts, prosecutors, defense teams, and constitutional law itself. And that leads directly to the third possibility. The reversal pathway does not necessarily mean the Supreme Court decision disappears. Instead, it means that the mechanics of litigation could slow or reshape the trajectory of the case. Lower courts retain authority over scheduling, evidentiary thresholds, and procedural structure. Appeals on specific legal questions could temporarily pause proceedings. Step by step, the legal momentum might slow. Not stop, but slow. And each delay would reshape the broader institutional balance between the executive branch and the judicial branch, because at its core, the significance of the 5-4 vote lies far beyond the individual defendant. A vote margin that narrow signals how contested the constitutional boundary truly is. It shows that nearly half of the highest court in the United States warned about the long-term consequences of opening the door to criminal prosecution of former presidents. Meanwhile, the majority concluded that the door cannot remain completely closed. That single vote difference, the fifth vote forming the majority, effectively redraws the legal boundary around presidential immunity. Before this moment, the doctrine existed largely in theory when applied to criminal liability. Now, the Supreme Court has clarified something: fundamental immunity is not absolute once a presidency ends, particularly when alleged conduct intersects with the integrity of elections. And that clarification may echo far beyond this case. Future administrations will study it. Future prosecutors will cite it. Future courts will interpret it, which leads to the constitutional question now quietly dominating legal circles across Washington and beyond. Does the authority of a president of the United States end at the door of criminal law once the presidency is over, or does the unique nature of presidential power require a broader shield even after leaving office? The Supreme Court has partially answered that question. But the final interpretation will emerge not from a single sentence in a ruling, but from the chain reaction that follows. And that reaction is already beginning. Within the next 24 to 48 hours, the lower federal court handling the case is expected to reactivate the procedural calendar. Clerks will issue notices. Judges may request scheduling proposals from both legal teams. Prosecutors are likely preparing updated filings built around the Supreme Court's decision. Those filings could reshape the legal battlefield immediately. They may redefine which allegations move forward. They may identify new evidentiary arguments. They may accelerate the timeline toward hearings that were previously frozen, while the constitutional question waited for resolution. The next procedural milestone will be simple in form but enormous in consequence: the federal court deciding whether to resume the trial path and under what structure. At that moment, the theoretical ruling from the Supreme Court transforms into operational law. And that is when the true implications of the 5-4 decision will begin unfolding in real time, not inside the marble hall of the Supreme Court, but inside the working machinery of the federal judicial system, where precedent, politics, and constitutional limits intersect under the pressure of history. For now, the United States finds itself in a waiting phase. The highest court has spoken. The majority threshold has been crossed. A constitutional line has shifted. But the next move belongs to the federal courts below. And the question quietly hanging over the entire system is no longer whether a constitutional precedent has been created. The question is how far that precedent will travel once the legal process begins moving again.